Well, hello everyone. Hello, Brian.
Hello, Cameron.
Welcome to our slightly unusual CTSI Symposium seminar being conducted remotely via Zoom. We're here to discuss professional practice and aspects of it today. Some of you may know me. I'm a barrister at Gough Square Chambers. I know all of you know Brian. He's not a man that needs an introduction, but that doesn't mean he doesn't want one. So with that said, Brian, what are we going to talk about today?
I will say who I am because people not noticing. I'm Brian Lewin. I did used to do a proper job. I started in weights and measures in August 1964. After 44 years and 6 months, I retired about 12 years ago, but I'm still involved in trading standards in a training role and ancillary sort of areas. Yeah, we're going to talk about professional practice, getting it right first time, doing the job properly. I honestly think that whatever job you do, people want to do the job properly. They get job satisfaction out of it. They get praise from other people when they get the job done properly. And professional practice in the trading standards area is knowing the procedures, following the procedures, and getting it right. And people are frustrated often by systems, often by lack of knowledge of procedures when things don't go right. They feel personally responsible, and it's very often not that person's fault in inverted commas, but we want to talk about just a few of the key areas that are frequently the subject nowadays of challenge.
Yeah, we're going to talk about 4 areas. The first, the ever popular topic of disclosure. The second, charging, which sounds simple, but there are a number of pitfalls, getting charging right and the issues that can flow from it if you don't. Thirdly, powers, the facilitation of investigation and to allow for prosecutions. It's a common ground of challenge that we in the courts see a great deal. And then finally, the old favorite, time limits. The format's going to be very informal, just Brian and I chatting really, but that's mostly because there's no one else here, so it's got to be us just chatting. We miss you all. We look forward to a time when we can see you back. And of course, if there are any questions that arise as a result of what we're discussing here, we'd be more than happy to try and answer them remotely in one form or another, emails or phone calls or whatever. So why are high standards of professional practice important? You asked me this question when we were thinking about this topic, and I said there was a short and a long answer as far as I was concerned. The short being lapses can result in injustice in what we do, wrongful acquittals, but also wrongful convictions. The more detailed answer is that high standards ensure best practice and result in fewer successful challenges to the investigator's hard work. Challenges by which I mean judicial review of things like the obtaining of warrants, the legality of warrants, the abuse of process applications that we see so commonly now relating to bias or failures to follow reasonable lines of inquiry or disclosure failings. Thirdly, challenges to the admissibility of evidence, improperly obtained, not obtained within your powers, shouldn't be allowed in the proceedings. Wasted costs that flow as a result of these sorts of applications if you have got it wrong potentially. And one of the things that, Brian, you often highlight, reputational damage, both in terms of the organisation, but also in terms of an individual and personal reputation.
Yes, and to pick up on what Cameron's just said, he used the word challenge a number of times, and I think we're in an era of challenge more than we've ever known. When I was an investigating officer, people used to plead guilty first time up. There were fewer challenges, there were fewer specialist lawyers, the law was less complicated. Trading standards were unfamiliar with taking cases in the Crown Court. The types of cases that you take nowadays, fraud, conspiracy to defraud, fraudulent trading, even where people are ostensibly as guilty as anything, they're going to challenge procedural matters, evidence gathering. I think this really, I can't believe you've done that to distract me.
I do. It was when you said guilty as anything. I didn't know, it just suddenly struck me. I don't know.
As innocent as Rebecca Brooks. An innocent person, as indeed Harry Redknapp. This is an era of challenge, and it's at all levels. During the course of what we're going to talk about, the procedures that apply just as much to a small district council as they do to the National Crime Agency. And it's no good saying, but we just took this and it's a fairly low-key case. I think Cameron has said to me in the past, you're more likely to get challenged in relation to some trading standards regulatory matters than you are in some of the more serious cases. And I think that's a theme of what we're going to be talking about in these 4 areas.
Certainly likely that the challenges are likely to be more successful potentially when you're acting in the regulatory field. But I think it was summed up quite well by Richard Foster, who was the retiring chair of the Criminal Cases Review Commission, when he said, and I quote, "Injustices can only be avoided if all concerned in the investigation of crime and the preparation of criminal prosecutions observe the very highest standards of integrity, conscientiousness, and professional skill." And that is essentially why, in very short order, professional standards and high professional standards are so important. So, with that said,
Cameron,
shall we?
Just excuse me, but that's the format. You just mentioned the word injustice, and I think miscarriages of justice, that phrase is bandied about. And if you ask the average person what do they understand by a miscarriage of justice, they would frequently say, and there are numerous examples of innocent people being dealt with by the criminal justice system, being found guilty, possibly being sentenced to terms of imprisonment, as I say, when they're innocent. And that is a miscarriage of justice. But the opposite side to the same coin is people who are guilty of criminal offences, of breaching the law, who are not properly dealt with by prosecutors, by investigators, by the criminal justice system. And the nub and the centre of both miscarriages of justice, it starts with investigating officers, and no investigating officer wants to be a person who's involved in a miscarriage of justice in either direction.
Yeah, agreed. So with that said, shall we start looking at one of our 4 areas that we've identified for today's talk? Disclosure.
Right, Cameron. Where is disclosure? Where does it start? Is this where you've prosecuted a person, they've pleaded not guilty, and you start scheduling some bits and bobs? I don't know. Is that where disclosure starts? He says, tongue in cheek.
It's obviously not where disclosure starts, but it is, from experience and in practice, regrettably, sometimes where it has started in a number of cases. Disclosure starts when the investigation starts. That's the law. That's what's required by the statute and by the associated code of practice. It's all about relevant material that's generated in the course of the investigation being recorded, retained, reviewed, and if it meets the disclosure test, revealed. That is the key 5 R's, as I'll term them, for disclosure as far as I'm concerned. And we know that failings in disclosure regularly lead to challenges in court. Pretty much every case I've been involved in this year has had a challenge along the lines of disclosure or similar. What about you, Brian, from an investigator's perspective, someone who used to have a proper job? What are the issues in disclosure for you? What's key? What's imperative?
Well, picking up on 2 words you just said, relevant and material, I think it's absolutely critical to recognise the meaning of the word relevant. Does it pertain to the offence? Does it pertain to the person? What about the surrounding circumstances? That's relevant. And to underline what Cameron said, we're not talking here about evidence. The evidence will be served. What's the other material that you have? We're frequently, in the trading standards context, talking about regulatory matters, matters that are strict liability, where there are statutory defences. You have a duty to investigate all of the surrounding circumstances, including statutory defences. And I would hazard to say, very infrequently will you have material that undermines your own prosecution, but there will be occasions. More frequently, you're going to have material that would assist a defence that's put forward by a suspected offender. And if I can give you a very simple but real life example in relation to underage sales, where there was a prosecution and the defendant's barrister said, well, have you ever taken test purchases from these particular premises before? Only at that stage did the Trading Standards Department reveal that they had, in the previous 12 months, taken, I think it was between 12 and 15 previous test purchases, of which I think it was 13 out of the 15 had not revealed in any sale. That's the sort of assisting of the defence material that has to be disclosed.
Yeah, I mean, I think the starting point for me with regards to all of this, and as a practical and indeed legal point for investigators, is know the legislation that backs it up. Know the associated code, know the CPIA, know the associated code, and that code sets out for you what relevant material is relevant to an investigation. If it appears to an investigator or to the officer in charge of the investigation, or indeed to the disclosure officer, that the material, not necessarily evidence, material has some bearing on any offence under investigation or any person being investigated or on the surrounding circumstances of the case, then it is relevant, and you must then record it, retain it, review it, and if it meets the disclosure test, reveal it. And that's been something aired in trading standards cases previously. We know about the Leatherland case, for instance, where this was an issue that was picked up on. But practically speaking, apart from knowing the legislation and the code, it's then organisationally having a clear and consistent approach to disclosure, having clear structures, template documents, allocating roles early in the investigation, ensuring that the people allocated those roles know what their job is within that role, and then applying the requirements of the CPIA and the associated code. It sounds simple, and it should be simple, and indeed the higher courts have regularly said something that on the face of it should be so simple seems to cause no end of problems. 5 R's: relevant, record, retain, review, reveal. Big pitfalls though. My experience has been quite heavily around digital disclosure at the minute. Huge volumes of material that have been seized from digitally from computers, etc. Is that something that you're aware of as being a big problem, Brian?
There are some trading standards cases where they've described the amount of material in terms of gigabytes. I've no idea what a gigabyte is, but helpfully for me, they described it in terms of copies of the Encyclopedia Britannica, and it was, you know, countless copies of that. It is phenomenal, the sort of material that trading standards investigations now encompass, and other barrister sets are available, but Gough Square Chambers do have barristers experienced in trading standards matters acting as counsel, disclosure counsel. And I've said this in front of a number of groups. If you're a Crown Court judge and you ask the question, who is responsible for the disclosure in this case? And someone like me says, Brian Lewin, I'm a trading standards officer. Oh, right. What's a trading standards officer? Cameron Crowe, barrister, Gough Square Chambers. Whether you like it or not, it's going to carry far more weight if your disclosure process has been carried out by a barrister. And can I just say here, Cameron, to re-emphasize something Cameron has just said, procedurally, you've got to get it right. That's an organizational responsibility in terms of equipping officers with the ability to record and retain, but then it's applying the procedures by the investigating officer and the senior investigating officer. And I don't use those terms lightly. They are the terms, as Cameron has referred to, the CPIA, the Criminal Procedure Investigations Act, Code of Practice. An investigating officer is defined and a senior investigating officer is defined, and they have distinct roles and responsibilities, and the senior investigating officer is the person who directs the investigation.
If you get this wrong, challenges come. People argue that they can't have a fair trial if the disclosure process is not robust. How can they be tried fairly if there's potentially material out there which would assist their case that the prosecution have been unable to review? That challenge is commonplace. It happens day in, day out in Crown Courts around the country, although not quite so frequently at the minute, but I'm sure they'll happen very frequently again relatively soon, or I hope so. The relatively soon, that is, not the challenges. But in terms of practical responses to that, in digital cases, there are practical responses. There are guidelines, Attorney General guidelines that assist investigators with regards to this process in digital heavy material cases. Disclosure management documents are absolutely key in my view. Get them drafted early, set out the approach that you're going to take to disclosure in writing, set out the fact that you need the assistance of the defense, force the defense into engagement in the process so that if they don't, or if they don't comply with the document that you've set out and served in writing early doors, you can turn around to the court when the inevitable challenges and complaints come and say, look what we did, it's in black and white. We gave it to the defense. We asked for their engagement. They didn't provide it in spite of repeated requests. And yes, I have to say, in the big cases where there's a lot of material, having a disclosure junior dip sample and look at some of the material to make sure the process is being done appropriately can be very, very helpful, and to ensure that the structures are in place. But frequently disclosure is causing an issue. Frequently, too frequently, we get it wrong. There's no reason to get it wrong in this day and age with the amount of guidance there is out there, and given the clarity on the approach that should be taken. Yet day in, day out, mistakes are made, and the approaches from one trading standard service to the next do seem to differ quite wildly, which is surprising. It should be pretty standardized in my view. But that's disclosure. Is there anything else you want to say on disclosure before we move on to topic 2?
Yes, just very briefly, case law and the frequent reviews of disclosure have all basically said the same thing. There's nothing wrong with the legislation. It's the application of the legislation. And the second point that Cameron has just absolutely really important point here is the criminal procedure rules, which obviously they govern disclosure as well, how disclosure. they talk about the participants in legal proceedings. There are responsibilities on the defence. It is not just a one-way street of the prosecution and the investigating officer looking through the material. The defence must participate in this process. And that's, I think, key to those 2 points are key to disclosure, Cameron.
Absolutely. Let's move on. Charging. Sounds like such a simple thing. You've investigated, you found evidence of wrongdoing, you charge the defendant, lay your information, summons issued, they attend the magistrate, off you go, you think you're off and running. But regrettably, there seems to be a lot of challenges these days to charging that take a number of forms. Some that come to me off the top of my head. I haven't thought about this at all. It's just off the top of my head. Elements of the offence. Whether you've actually got evidence to back up the elements of the offence in the charge. Secondly, whether you had the evidence to charge at all in the first place. Was it right to actually bring the charge? Was it justifiable? Thirdly, legal identity. Have you charged the right entity? Fourthly, the consequences of getting the charges potentially want on post-conviction orders and similar. Confiscation springs to mind. We know that there have been some recent cases where the charge related, for instance, to one day rather than a course of conduct, and that had huge consequences as far as confiscation was concerned. So the charging process is now something that is being challenged regularly. Brian, what do you think?
Well, the first point I think is there is a CPS, Crown Prosecution Service code for Crown prosecutors. Please don't fall into the trap of saying, well, that doesn't apply to us. The appellate courts have certainly said that you should have regard to that. When you're charging, have regard to the nature and extent of the offending. Have you given the court appropriate sentencing powers? With the greatest respect, some of the charging of matters under the Consumer Protection from Unfair Trading regs should never have been prosecuted under those regulatory areas. Unfair commercial practices, they're out and out fraud. If it looks like a fraud, walks like a fraud, quacks like a fraud, prosecute it as a fraud or similar. The extent of the offending, who has committed criminal offences. I can never pronounce the word inchoate, but there are a range of additional offences: encouraging, assisting crime, aiding and abetting crime, conspiracy to fraud. I think Cameron was involved in a conspiracy where there are 18 separate conspirators. That there are other offences that can bring in all of those engaged in the criminal activity. And last but not least, and Cameron's already mentioned this, you are obliged to have regard to post-conviction orders, but specifically in relation to confiscation. And I know that this is an area that Cameron and other barristers wallow in, is that the correct term? It is such a fruitful area. Cameron's been involved in a confiscation order of £1 million. Trading standards involved in confiscation of £1 million. It's absolutely imperative that not only do you prosecute, but that you deal with the people involved with appropriate confiscation orders. Many years ago, I was involved in a prosecution where Jonathan Kirk applied for a company disqualification order, and the person was disqualified. Well, he was sent down for about 9 months, disqualified for 12 months as a company director. He actually cried in the dock at the thought of not being a company director. The range nowadays of these post-conviction orders is very wide, and I'm absolutely delighted to see that trading standards yet again are innovative in their approach to these orders.
Yeah, absolutely. But boiling it down then, when it comes to charging and the issues around it, those challenges take various forms. The starting point for me, and you mentioned the CPS code for Crown prosecutors, is reviewing the evidence to check that you have a realistic prospect of conviction for the offence that's been identified. Secondly, that it's in the public interest to prosecute. And thirdly, for trading standards and local authority prosecutions generally, that it's in accordance with your enforcement policy. Because they've all got to have one, and how frequently is that actually expressly referred to, and how frequently is it actually challenged these days? Number of times you hear people say, well, is that in accordance with your enforcement policy? Or you'll get a letter saying, well, your enforcement policy says that, you know, you give us a cuddle first rather than prosecuting us. How have we ended up here? So that's your starting point. They're your imperatives. Look at the evidence, consider the elements of the offence. Is there a realistic prospect of conviction against the individual, whether corporate or otherwise, that's been identified, the entity identified? Is it in the public interest to prosecute that person? Is it in accordance with your enforcement policy? And if so, get all of that in writing. Get it all in writing so that when a challenge comes, you've got it there in black and white. You've considered all of the relevant aspects you need to in making this charging decision. If you've done all of that, it's very, very unlikely that the higher courts or the Crown Court or anyone else is going to consider that you've got this wrong and that you've done this unreasonably. The higher courts have repeatedly said that they will only interfere in the wide discretion available and afforded to prosecutors in the rarest of circumstances where there's a need to, an absolute necessity to. So that's the starting point. Legal identity is something we've mentioned in relation to that, and there have been a number of cases that I know that you follow quite closely, Brian. You've got a big thing about getting the identity of the defendant right, and rightly so. But that's been something that you've looked at specifically.
Well, I think there's unfortunately a succession of cases which just show that poor professional practice has not identified the true legal identity. I think the starting point is to recognise legal identity. Is the person a sole trader? Are they a partnership? Is it a limited company? Is the person that you're dealing with a director of a limited company? I'm sadly reminded of a PACE interview where the investigating officer said to the person, are you a sole trader, a partnership or whatever? And the guy said, I'm a sole trader trading as XYZ Farms. And the next question was, are you a director of that company? And that, was basically unprofessional practice. So getting the correct legal identity is one of these areas. If you don't get it right, like time limits, it's fatal. There's no opportunity. There's no possible amendment under the relevant section 123 of the Magistrates Court Act.
There it is. There it is.
No opportunity, sad git that I am to know that. No opportunity to amend, and you're out. And there is a case involving a well-known supermarket where basically the local authority just didn't get it right for the letter S. And there's plenty of supermarkets, and you'll have to look at the case law, and we can provide you with the details afterwards. So that's a really important area, legal identity, yes.
It was summed up by Lord Justice Tracy in Crown Investments Limited versus North East Essex Magistrates Court in 2017, wasn't it, Brian? Just off the top of my head, again, it just, you had section 123, I had Crown Investments, where he said there is a degree of factual inquiry necessary before the court can distinguish between a mistake as to identity, which cannot be corrected out of time because of section 123, and a misstatement of a name which may be corrected out of time. That's a key distinction there, isn't it, Brian?
It is, and digressing, I had the privilege in the dim distant past of instructing Coleman Tracy when he was a mere barrister before he became Lord Justice Tracy.
Did you win?
It's a sad story.
So no. Oh dear, never mind. Well, so on charging decisions, I mean, if we look at some of the consequences that can occur, one, of course, is that you have your decision to charge, decision to prosecute challenged in its entirety. There have been a number of cases along those lines recently. A couple that spring to mind is Crown versus the Knightland Foundation, Wokingham Borough Council versus Scott. These were both cases, weren't they, Brian, revolving around local authorities that had essentially brought prosecutions on the evidence solely to make money out of confiscation.
The inescapable fact was that the decision to prosecute was a decision based solely on the obtaining of a confiscation order, even when there was an opportunity to end the prosecution. The local authority continued, and this has been a fruitful area, and there have been some unsuccessful challenges subsequent to the two cases that Cameron has mentioned, but it does show that this is something that is going to be critically examined. And can I re-emphasize something that Cameron said, and that is recording decisions. Record. You've got to have an enforcement policy by law. The regulator's code says you've got to have it, and it's a statutory code, and you've got to adhere to it. So record your decision making fully, and do not fall into the trap that those local authorities did in those cases. But the challenges are much wider, and as Cameron has said, public interest grounds. We had a recent case that I'm sure Cameron will know better than I, but basically on public interest grounds, if you prosecute us, we'll lose our business and people will lose their jobs. So please don't prosecute us. And the courts looked at the procedures taken in that case by the Health and Safety Executive, which included the regulator's code, the policy decisions, etc., and found that the decision-making process was appropriate.
Yeah, it was a big case in Health and Safety Executive prosecution recently, wasn't it? And they challenged the decision and they were told where to go because they could identify that they'd taken the appropriate factors into account when making a decision as to whether there were both realistic prospects of conviction and whether it was in the public interest to prosecute. I'm conscious of the time ticking along, so we should probably skip on to our third item of 4, which is powers. And I believe powers is something that you do a day-long course on, isn't it, Brian?
Yes, another. I used to, before lockdown, all of our online courses are now 2 hours. That's the maximum length of time that anyone can possibly listen to me or watch me.
I think we're trying to prove that it's shorter, in fact, via this, but let's see how we get on when we get the feedback. So powers, what are the key considerations here? For me, it's knowing them. Knowing what your powers are seems a pretty good starting point. If you know what your powers are, then you can act within the scope of those powers. Recognize the consequences if you don't. Recognize the sorts of challenges that you might receive as a result, and recognize the possible damage that can be caused by acting outside the scope of your powers. Seems a reasonable starting point, doesn't it?
Yeah, absolutely. And I think for the most part, in relation to fair trading matters, nowadays, because of the consolidation of powers, many trading standards officers will be using the powers in Schedule 5 of the Consumer Rights Act, even if the end of the investigation results in prosecutions for fraud, Section 1, 2 Fraud Act, or for fraudulent trading, etc. And something Cameron and I have talked about on numerous occasions, it is absolutely critical that you can identify an offence under the Consumer Protection from unfair trading regulations or the business protection regs if it's a B2B matter. If you're using powers, because there are no powers under the Fraud Act, there are no powers for under conspiracy to fraud or fraudulent trading. So it's really, really important. That's not such a big burden. Cameron and I, again, have looked at so many different scenarios and said, yeah, that's a fraud. That's going to be prosecuted as a fraud. Was it also an offence under the CPRs or the BPRs? And the answer 100% of the time is yes. We can frame an offence under that legislation. It's really important, therefore, that officers, when executing powers, recognise the power in Schedule 5 of the Consumer Rights Act and the qualifications that relate to those powers, because the power may require you to have reasonable suspicion that a breach of the enforcer's legislation has been committed, reasonable suspicion that there is a breach of the CPRs or the BPRs.
Your reference to the CPR and BPR,
Yeah.
or CPUT and BPR as I like to call it.
Forgive me.
Well, because there are so many CPRs for us,
Indeed.
civil procedure rules, criminal procedure rules. Anyway, that aside, often from experience, one of the issues that will arise is whether the victims or complainants are consumers or not. That seems to be one of the things that is challenged, which makes obviously no difference in the context of a fraud. It's not going to be a key feature, but when you're having to use powers based on the CPRs or BPRs, it's important, in my view, to recognize that if that is an issue and deal with that issue early doors by saying, well, we recognize that some of the complainants are consumers. We utilize powers under CPR for that, or under the CRA in relation to the CPR. But if we're wrong, then they fall under the BPRs in any event. Just making sure that, again, you're recording this so that you can, if this is challenged in due course, say, we've considered this issue. We've had that issue at the forefront of our mind and we've addressed that issue and we've addressed it appropriately and in accordance with the legislation. But there were two other common issues, it seems to me, from experience relating to powers, other than, did you seize this evidence lawfully or not? Was your approach under Schedule 5 of the CRR correct? The first is, if you're really looking at potentially a fraud or a money laundering offence and you're trying to squeeze it in under CPR, BPR, is that legal? Now, there's been a case on this recently, hasn't there, Brian? Investigating Qualters.
And you're going to tell us all the facts and the ratio of the decision in the case. So you caught me on the hoof.
Oh, sorry. This is the Northwest case, the Qualter case, yes, that everyone's heard all about. Of course, I knew that. The big point arising out of this is that they try to, Qualter and others try to limit the ability, the powers of the investigators to investigate. And importantly, the High Court said, no, this is an investigation. You've got the power to do all of this in your investigation. It's a separate question to answer whether you're within the scope of Section 222 when you prosecute it, but that is a separate question to be dealt with at a separate stage at a separate time. But that leads us to that question, and frequently abuse of process arguments are raised on the basis of Section 222, and they have been for years and years and years.
At this point, I'm just going to just pick up on something that Cameron's just said. He's mentioned challenges. He's talked about inadmissibility of evidence, judicial review, abuse of process, all of which could occur at the stage that you're actually in court. Cameron has emphasised to me many occasions in the recent past, challenges are made outside of the courtroom. challenges are made when local authorities have indicated they're going to prosecute. And defence lawyers have said, if you prosecute in this matter, this is the type of challenge we're going to make. We are going to say the officers' powers did not permit them to do this, and that rendered the seizure inadmissible. It is not necessarily a courtroom challenge. This could well be something that is challenged before the case ever goes to court. And remember something else that Cameron said at the start: reputationally, do you want that situation? You haven't even gone to court and there's a successful challenge being made.
It's an important
powers. There are numerous issues, but I think, again, to go back to something Cameron said right at the beginning, knowledge of powers, knowing what your powers are. What are your powers? And sadly, I have to say, and it's a few years down the road now since the Consumer Rights Act Schedule 5 came into force, there's a fundamental misunderstanding of some of the powers, powers that are absolutely dependent and consequential to lawful entry into premises. And more importantly, I think, is a failure to understand properly the merits, not the disadvantages, of the power to require a person to provide you information. And paragraph 14, and people have said, well, that's a rubbish power because that information can't be used in evidence against the person who produced it. That's technically right, but your job also is to provide information to the decision maker, going back to decision to prosecute. Is there sufficient evidence? Is there a reasonable prospect of conviction? If you've not received the evidence, the information from the person, how are you ever going to know? And I think that fundamental misunderstanding of what information can be obtained under paragraph 14 is a sad indictment on our profession.
It's an interesting point. It wouldn't be one of our talks ever if we didn't have a slight disagreement, would it?
Indeed.
So paragraph 14, I think, is very useful, but it's mostly useful for using against third parties who are not probably going to be defendants in the case, because it's a very useful way of getting evidence from them. As far as trying to find out what the position is from a potential defendant's perspective, that's really what the interview is for. And if they choose not to answer questions or attend an interview, then that's to an extent going to fall on them. You've done something from the investigator's perspective that's perfectly appropriate. You've sought to ask them questions to get their side of the story, and if they haven't given it to you, then that's down to them. So I think para 14, I agree with you, para 14 is very, very useful, but I wouldn't necessarily deploy it that frequently against a prospective defendant. I'd suggest it be deployed more against third parties.
Well, again, you've picked up on a really important point, Cameron, in terms of the interview, the opportunity to ask questions, to see whether the person...
You're going to say you don't have any power to interview, aren't you?
Yes, well, if the person is interviewed, of course, being interviewed, sadly, you and I both know, Cameron, we've dealt with queries from training standards officers who said, during the course of the interview, I used my power to ask the person to provide information. Unbelievable that they should... that power has to be in writing in any case, but an interview is an interview, and the use of powers as the use of powers, they are quite separate. They
are. It's an important point. I've seen letters drafted that blur the two as well, seeking to exercise powers by seeking information under para 14, but then concluding with a caution, as if it were an interview. Anyway, again, conscious of the time. Anything else you want to say about powers? Know them, act within them, but recognize that if you know them. As far as the wider scope of criminality, fraud, etc., your powers should allow you to properly investigate those cases and those crimes without difficulty.
Also, be aware of the change in law which enables investigations across local authority boundaries in England and Wales.
Yeah.
It was half touched on, not fully explored in the case that Cameron mentioned, the Qualter case. Somewhat unfortunately, it was raised at a late stage. It's rather a pity that paragraph 46 wasn't looked at, but in summary, you do have the power to enter premises across local authority borders to investigate consumer offences, if I can call them those.
Which includes offences that arise out of a consumer offence. So it includes fraud.
Really important point.
Yes, that is a good point. It wasn't heard by the High Court in Qualter. They said it was raised too late, but it has been heard in numerous arguments before Crown Courts up and down the country. I've certainly been involved in a couple in the Crown Court, have followed Para 46 and concluded that power, if it didn't exist already in Section 222, and given the wide ambit of 222, then it definitely exists in Para 46. So, yeah. So quickly and appropriately, given we're running out of time limits. One of your favourite areas. You love time limits.
It's the second of the two fatal areas. You get this wrong, you're out of time. The question I frequently ask groups on professional practice courses: when does the investigating officer look at the time limit when they're putting the report together? No. The time to look at time limits is right at the start, and recognise the different wording of time limits for summary only offences, 6 months from the date of the commission of the offence. But in other pieces of legislation, it might say something, for example, 12 months from the date at which evidence came to the prosecutor's attention, or whatever. They're phrased differently, and it is absolutely important that investigating officers understand, know and understand the time limits that apply, so that you can, to go back to the charging decision, prosecute for appropriate offences. I'm sad to tell you of a case I'm aware of where misdescribed furniture that was also a fire hazard, unsafe, was prosecuted. It was out of time for the safety matter, but in time for the misdescription. What was the more serious offence in that case?
The question you asked is absolutely key. It's the first question to ask yourself when considering time limits. What sort of time limit is it? Or more accurately, what sort of offence is it that the time limit applies to? Is it a discovery offence, or is it a sufficiency of evidence offence? The approach is different. The case law surrounding the two is different, and once you've established that, then you're going to have a clearer idea of when your limit is going to be. From a practical perspective, have from the very outset in the front of your mind when the likely time limit is going to be, and try to avoid submitting your report the day before and laying the information just before, because it nearly always results in arguments, even if you're in time. There have been a number of cases recently that haven't gone our way, in that they were held to be out of time. The worldwide tickets case was probably the most prominent example recently. Wouldn't you agree, Brian?
Yeah, I wouldn't want to go into all the details of that particular case, but a theme, I think, is that you can't artificially extend time limits. And talking about extension of time limits, of course, there is a permissible extension of time limits if you're dealing with a primary authority matter, but it's only a short time. As Cameron has said, there is a succession of recent cases in this area. There was a case involving large supermarkets a little while ago where there was a summary of why do we have time limits, and it is to bring about an expeditious investigation of offences by investigating officers. It's natural justice that matters are brought before the court as soon as possible. And leaving it to the last minute, I forget the exact quote, but I think it's fraught with dangers.
It is. Your mentioning of Reza reminds me, I've had two cases recently where there was an argument that the breach of Reza was an abusive process. It resolved because the Reza scheme didn't apply. There had to be a finding of fact of it, but there was an argument on that very line. And then secondly, that a breach of Reza meant that the entire prosecution was null and void, not an abuse, it was just null and void. There was no jurisdiction to hear it. That argument also failed. They haven't gone up to the higher courts, but it's a good point to make about Reza and the fact that there are time limit arguments that surround that as well. So, and with that, we are running out of time, Brian. So it's, I think, going to be, in the absence of any questions, anyone? No, I think it's going to be goodbye from me and goodbye
from him.
Yeah, exactly. Misquoted, I think, there, but hey. Anyway, we hope you found it remotely useful and entertaining, and we look forward to seeing you soon.
Indeed. Bye.